I'm John Sadler, president of Sadler Sports and Recreation Insurance, and we insure over 15,000 local sports organizations and over 30 national and state sports associations. And based on my 35 plus years of experience, I've had the chance to review a lot of insurance policies. Some are good, but unfortunately many are not so good. The insurance decisions that you make are important because your organization and players and administrators, employees, and volunteers are counting on you to make the right decision for their protection. But insurance can be complicated. Policies can be hundreds of pages long. They can be full of technical insurance jargon, and you can have dangerous policy exclusions hidden in the fine print. The intent of this training today is to cover the basics of sports insurance and waiver release, and to give you the tools you need so that you can review and improve your own program. Our insurance carriers pay a lot of claims on behalf of our sports insurance clients, so I know that they're receiving an excellent value for their premium dollar. Most general liability claims settle for under $50,000, and most accident claims settle for under $5,000. We see a lot of spectator slips, trips, and falls on parking areas, fields, walkways, bleachers, and bathrooms. Spectators are frequently hit by balls or they're run into by players near boundaries. Players and coaches are injured during practices, games, and non-sport outings. We see player injuries due to improper supervision or instruction. Improper supervision is the #1 cause of action filed against youth sports organizations. And I can tell you that the NAYS training can have a positive impact on reducing these types of claims. There are field and facility problems due to improper design and maintenance, equipment problems due to improper selection and failure to replace or maintain. We see failure to provide adequate sports injury care, whether first aid or more serious emergency care. And also we see claims involving property damage to fields, facilities, equipment, and spectator vehicles. This is just a sampling of some of the actual severity claims that our clients have filed over the past 20 years. Some are what you might expect, but others are hard to imagine. The expected ones are heat stroke death, bleacher collapse, spectator being hit by overthrown ball, and even sexual abuse. But some of these are just crazy and totally unexpected, such as defamation, falls off parade float, drownings, and improperly placed signage which resulted in an automobile fatality. But that's why you buy insurance, to protect against the unexpected. I'm going to be talking a lot in this presentation about how to access free risk management resources on our website at sadlersports.com. When you go to the home page, click on the Risk Management tab, and first-time visitors will need to enter their name and email address. But as you scroll down, of particular importance today would be the Choose High Quality Insurance section, and you can find the 2 checklists I'm going to be talking about. And also, if you scroll down to Contractual Transfer Risk, you're going to find a lot of information about waiver release forms, which I'm going to be talking about today. You want to choose high quality insurance that meets certain minimum standards. The 5 most common policies that are needed by all sports organizations would be excess accident, which pays medical bills on behalf of injured participants, general liability, which covers certain lawsuits alleging bodily injury and property damage, directors and officers liability, which covers certain lawsuits arising from managerial negligence and employment practices violations. Also, crime insurance, which covers financial loss due to insider embezzlement and theft of property, and equipment, which covers financial loss to equipment due to fire, wind, theft, and vandalism. And you want to have adequate limits to provide protection against the statistically likely worst-case scenarios and to meet the field and facility owner requirements. You also want to avoid problem exclusions. An exclusion means that something is not covered by the policy. There are other policies that may be needed by sports organizations such as workers' comp, auto, property, and cyber risk, but that's beyond what we're going to talk about today. Let's talk about the excess accident policy. This policy is the first line of defense against lawsuits, and it is required by most general liability carriers as a precondition of coverage. The reason is if excess accident guarantees that the parent or the participant is going to have no out-of-pocket medical bills, that takes away a lot of their incentive to file a lawsuit in the first place. Excess accident requires other collectible family health insurance to respond first, which can result in three scenarios. The first would be if family insurance pays 100% of the bills. In that case, excess accident pays nothing. The second is if there is no family insurance, the excess accident becomes primary and pays from the first dollar up to the policy limits subject to its own deductible. The third would be if family insurance makes a partial payment. In other words, it doesn't cover everything because it has its own deductible or co-insurance. In that case, the excess accident will pay the difference subject to its own deductible. The medical limit should range anywhere from $25,000 to $250,000, and the medical limit must be high enough to satisfy the general liability carrier's requirement to offer participant legal liability. And most general liability carriers will require at least a $25,000 limit on the accident policy. The deductibles on an accident policy should range anywhere from $0 to $2,500, and the higher the deductible, the greater the premium discount. The payout should be based on 100% of the reasonable and customary medical expenses. The covered persons definition should include all participants, including athletes and other staff. The definition needs to be broad enough to meet the general liability requirements. The covered activities definition should be broad enough to include all exposures, not just tryouts, games, practice, and tournaments, but also other sanctioned and adult supervised functions, as well as travel to and from. And finally, the insurance carrier should be rated at least A- by AM Best. You want a financially strong insurance company to make sure they're going to be in business to pay a future claim. Let's talk about the general liability policy. Covered persons should include the sports organization as an entity and respective directors, officers, employees, and volunteers. The policy typically only provides coverage during sanctioned and supervised activities unless the coverage is expanded to include the ownership and maintenance of fields or facilities. The policy covers certain lawsuits alleging bodily injury, property damage, personal injury, which is defined as slander and libel, and advertising injury. The policy covers legal defense, settlement, and adverse jury verdict. And I can tell you that legal defense is often the most expensive part of a lawsuit and in many cases exceeds the settlement or the adverse jury verdict. The typical minimum limits to provide adequate protection and to satisfy facility owners are as follows. The each occurrence limit is by far the most important limit on a sports liability policy, and you want to have it be at least $1 million. However, there are some field and facility owners that will require a $2 million each occurrence limit. The next limit is a general aggregate, which should at least be double the each occurrence limit. This comes into play because there's an aggregate cap on the policy if multiple lawsuits are filed during the same policy year, but we don't see this too often in sports. The next limit is the products and completed operations aggregate, which should be at least $1 million. Products and completed operations comes into play in the event that you're sued due to sale of a faulty product or some type of a completed operation, such as a construction project. Next would be $1 million personal and advertising injury limit. And personal injury is, think of slander and libel, and advertising injury would be if you disparage a competitor in your advertising materials. And next would be a $300,000 limit for damage to premises of others. which is also known as fire damage legal liability. And this comes into play in the event you have a short-term rental of a facility. It would pay up to the limit in the event that you damage, primarily by fire, that facility. Next would be $1 million participant legal liability. Many sports insurance policies have this limit, which is an affirmation that you do have coverage in the event of injury and lawsuit to a sports participant. Now, higher limits are typically available for an additional premium charge, and I can tell you that in order to increase your each occurrence limit from $1 million to $2 million, that's normally a 20% surcharge. Now, I strongly recommend that you purchase some optional coverages to tack on to your general liability. The first would be $1 million non-owned and hired auto liability. Now, this comes into play because your sports organization can be vicariously liable for the driving activities of your employees and volunteers while they're running an errand on behalf of your organization. And in the event they don't have their own adequate personal auto insurance, the person who's injured can also sue your entity. This also comes into play when you go to a rental car company and rent a vehicle. It does provide automatic liability coverage, but not physical damage. Also, I strongly recommend that you have $1 million sex abuse and molestation endorsement tacked onto your policy. This definitely coverage you want to have. And finally, if your organization owns or is responsible under a lease for the premises, you want to have 24/7 premises liability coverage. Now, I'm not talking about a short-term like lease for a couple of hours. I'm talking about a long-term lease for a period such as a year is when you need this coverage. And also, the insurance carrier should be rated at least A- by AM Best. This is a list of general liability problem limitations and exclusions to avoid. Claims made, coverage form. You just don't want a claims made policy form in the context of a sports organization. Claims made policy forms don't do a good job of protecting against a delayed reaction lawsuit where a child who's injured at age 4 or 5, for example, could wait until the age of majority, age 18, plus an additional 2 or 3 years for the statute of limitations to run before filing a lawsuit for an injury. The policy may not provide coverage for that, but if you have the superior occurrence policy form in place, it will provide coverage years later. And next is the athletic participants exclusion is an absolutely terrible exclusion to have on a sports policy. That basically means that you have no coverage if there's injury to an athlete or another staff member who's a participant, and if they file a lawsuit. So what you're left with is only coverage for spectator injury lawsuits. And there's a new limit in the sports industry called participant legal liability, which was added to affirm that the athletic participant exclusion is not present and that you do have the coverage that you need. And next is sex abuse and molestation exclusion, which I think it's a risky exclusion, and you should buy this coverage back if the option's available. And next we see a total brain injury exclusion. Sometimes it's called a neurocognitive exclusion. You don't want to have a total exclusion on your policy. Now, it's very common in the industry to have a brain injury limitation endorsement, and most of those are bearable. And next is what's called the participant versus participant exclusion, which is very common in sports insurance. I really don't like or understand this exclusion because under the definition of a participant, you have both a player and a coach. So, for example, if a player sues a coach, it could be excluded by this by this exclusion here, and I don't think that's what the intent is of the policy. So I like to change this to a player versus player exclusion, which is more favorable if possible. Also, there's the punitive damages exclusion, which some carriers have. Punitive damages are asked on most lawsuits, but winning them can be difficult. But I like to try to negotiate or eliminate this exclusion off the policy. And there's also some other problem exclusions, which I'm not going to cover today, but they are covered on the checklist on our risk management webpage that I will make available. Let's talk about the directors and officers liability policy, which is often combined with an employment practices liability policy, and frequently both in combination are referred to as a management liability policy. Covered persons should include the sports organization as an entity and the respective directors, officers, employees, and volunteers. Now notice this is the same definition of covered persons that you have under a general liability policy. But I often get asked, can a director or officer only buy this policy, which is typically less expensive, and does that do away with the need for them to buy general liability coverage? The answer is no. Directors and officers need to be covered under a general liability policy also, because a general liability policy covers lawsuits that allege bodily injury and property damage, but directors and officers liability does not cover those types of lawsuits. Instead, directors and officers liability will cover lawsuits arising out of managerial negligence and employment practices violations, such as discrimination based on race, sex, age, or handicap. And we see a number of handicap discrimination lawsuits under the Americans with Disabilities Act. Also covers wrongful suspension or termination of staff or players. It covers failure to follow your own rules or bylaws when you make an administrative decision. And it also can cover violations of rights under constitutional, federal, or state law. And we frequently see free speech lawsuits here. The policy provides an attorney for your legal defense and will pay up to the policy limits for settlement or adverse jury verdict. And the common limits we see are $1 million or $2 million. And this policy is relatively inexpensive for a local sports organization. The premiums can range anywhere from $300 to $500 flat charge. So the big question is, how do you know if your insurance policies provide adequate protection? It's very difficult for laypersons to analyze insurance policies. Exclusions and limitation pitfalls are often buried in the fine print. Now, we provide 2 detailed checklists on our risk management webpage to help verify compliance with certain minimum standards that the policy should comply with. We have one checklist for local sports organizations such as teams, leagues, camps, and tournament hosts, and we have another checklist for municipal recreation departments that buy their own insurance. All you have to do is submit the checklist to your insurance agent and ask for them to complete it. They'll have to indicate whether it does or does not meet the various minimum standards and ask for their signature. And this will probably lead to some more follow-up discussions with your agent and possibly ways to improve your coverage. Let's talk about waiver and release agreements. They're often a requirement of general liability carriers as a precondition of coverage. They're definitely worth the paper they're written on if they're properly drafted. Also, electronic waivers do hold up in court, and we quite frequently see them with online registration processes. I think you need to get them for both your youth participants and your adult staff. They definitely work better for adults in terms of immediate lawsuit dismissal, which is called summary judgment. Now, parents can only sign away the rights of minors in a minority of states. But waivers are still valuable for minors even if they don't result in an immediate lawsuit dismissal, because they can serve as an evidence of an assumption of risk defense, and they can also lower the insurance carrier settlement cost because they're just one more hurdle that the plaintiff's attorney needs to overcome, which is expensive. See our webpage for a state-by-state account of the enforceability of waiver releases. And one final thing is that they will never be given any weight or value if they're poorly drafted. When drafting a waiver release agreement, there are certain pitfalls that should be avoided and magic words that should be used. And this is just a list of some of the most important ones. First of all, the wording should not be unclear or ambiguous. The size of the type should be at least 10 point. Also, don't make the mistake of commingling on the same page with other participant registration documents. The waiver release needs to be a standalone document. Also, gang signatures pages are frowned upon. You commonly see a waiver release agreement that's just one page where all the parents sign, and those evidently are not as strong as individual pages with individual signatures. The waiver should include the phrase, in consideration of being allowed to participate. The reason is because it's a legal contract, and in a legal contract, consideration or something of value must be provided by both sides. Also, the wording should include permanent disability and death. You don't want to try to water down the waiver release by acting like something like that could never happen. And all risks should be assumed, both risks that are known and unknown. And the organization should be released to the fullest extent permitted by law. This phrase allows the waiver to still be of value even if some parts of it are not permitted by state law. And I can also tell you that a new waiver is required for every registration period. These are all principles that your attorney should use in drafting a waiver release. So what can you do to improve your waiver release? In my experience, many waiver forms are poorly drafted and will carry no weight whatsoever with a court. You want to avoid the drafting pitfalls and use the magic words that we discussed on the last slide. One tip is, in the past, we were really concerned about injuries, but now I think you want to go ahead and add reference to communicable diseases as a release risk due to the COVID pandemic. Another tip is you want to add special language so minors arguably don't have to sign. When you have an electronic waiver release, it can sometimes be difficult for the minor to be available when the parent is completing the form. The Sadler Risk Management webpage provides sample forms for minors and adults, but it's always best to have a custom waiver drafted by an attorney just for your state and your activity. But in my experience, most clients I have are not going to pay to have that done. And also, you need to retain the waiver release for 17 years because remember, a child who's age 4 can wait until the age of majority plus another 2 or 3 years for the statute of limitations to run. And you never know when you're going to have to reproduce the waiver release. Thanks for your time today. I hope you found this information to be both valuable and actionable. And remember, if you need to access any of our risk management information, just visit our website at sadlersports.com and click on the Risk Management tab, and we'd be happy to advise you on any of your sports insurance needs as well. Thank you.